Jo, what I was wondering about was if you have a particular process to the way that you approach your cases when you get them.
I do, and it's been, BB, the same process I've adopted for about 25 years. It's really basic, and it's really simple, and it really works. And it goes like this. So what I tend to do is, whether the case papers, that's the witness statements, the documentary exhibits, etc., are in fact uploaded to the digital case system, or whether I am actually given hard copies, all of my papers end up in a lever arch file or 2 or 3. My objective is always to slim down the papers that I really need into not a lever arch file, but a slim file. So it becomes extremely important to me to do the sifting exercise, the filtering exercise, so that I can focus on what really matters. So stage 1 for me is get all my papers together and order them. I have a particular approach, a formulaic approach. I like to use tabs in my file. My first tab in my file is invariably the case summary. That's prepared by the prosecution. The next tab will be the indictment. The next tab will be the list of witnesses. The fourth tab will be the actual witness statements that I'm going to need for the trial. In other words, the witnesses who I'm going to be cross-examining. The next tab will be my list of exhibits. The tab after that will be the actual exhibits, the documentary exhibits, which are going to be important for me to have to hand in the trial. And then after that, I've got a tab for what we call unused material. Then I've got a tab for my client's instructions in a proof of evidence. I will have a tab for the defense statement. And finally, I will have a tab for correspondence. And all of that gets pared down to a file that ultimately is a slim file that I can walk around with. It's my walk around file. And this is really important because if I tell you what my style of advocacy really boils down to, it's this. It's about minimizing the material which you've got to only those essential papers that are going to be used and deployed in the context of the trial. And the rationale behind that, BB, is to remove all extraneous matter which can distract you. And I'll come on to this in a minute when I talk about how I prepare my cross-examinations when we get to that. But for the first stage, it's this. Think of an advocate as essentially an accountant. An accountant crunches numbers, an advocate crunches facts. So when I teach case analysis to young barristers and we talk about how you dissemble the information which you've got, I will say to them, you've got the relevant law, which you must make sure you're on top of. That's to do with the statute and the authorities which are relevant and including criminal procedure rules or civil procedure rules. Then you've got the actual material in your case to do with the facts. That's the witness statements, the exhibits, etc. And what you're looking to do is to condense that information, crunch it down, a bit like an accountant does, so that you only have the bare essentials. The first stage is organize your material in a way that works for you. And I'll mention one other thing about this as well, BB, and it all sounds very, you may think, my goodness, this sounds like he's preparing for his GCSEs or his A-levels. You know, has he really been doing this all his career and managing to get by? The answer is yes. And I'm going to tell you what I do. I use highlighters like they're going out of business, right? For me, highlighters are an absolute godsend because when you talk about preparing for your case, identifying what really matters is crucial when I talk about crunching facts. So let me tell you what my little system is. I use a pink highlighter for dates and times. I use a green highlighter for locations. I use a blue highlighter for any exhibits that are mentioned in a witness statement or on an exhibited document. I use an orange highlighter for anything that relates to my own client and only my own client. So, for example, if it's a murder case where there's 3, 4, 5 defendants and I'm representing one of them, my client will get an orange. That's what he gets because that's about him, because it helps me to focus on what that witness is saying about him. And then I'll use a yellow highlighter for just, contextual things. And what that means is this. When I stand up and I have a witness statement in front of me and I've highlighted it in the first tranche of work that I've done in preparing the case. I've already done that highlighting thing where I've seen what really matters, dates, locations, and all of that. My eyes don't dance around the page. I don't confuse myself and start thinking, oh my God, where is it? I know it's there somewhere. Was it on the second page? Was it on the third?